Crystal, are we ready?
Yes, we are. Good morning and welcome to our webinar, The Dangers of Do-It-Yourself Wills and Estate Planning. McCulloch Miller is an elder law and estate planning firm in Houston with offices in the Galleria and downtown areas, and we hold workshops both online and in person, once it's safe, on a monthly basis. We're glad you're here with us. My name is Crystal and I'll be today's host. Our speaker is the partner David Miller, but before we start, I'd like to point out a couple of items. This is being recorded and you can turn your camera off or keep it on if you'd like, but we'll ask you to remain muted throughout the presentation. The chat box is for questions that'll be answered toward the end, and then there will be a survey sent out directly afterwards that will allow you to input any ideas for future presentations or set up a free consultation with us if you desire to do so. At this time, I'm happy to turn your attention to Mr. David Miller.
Okay. Well, good afternoon. Thank you very much for joining us. My name is David Miller. I'm a partner here at the firm. I know right now is a time of, with COVID out there, it's a time of kind of uncertainty, a lot of bad things going on, but I hope that at least you are able to enjoy the upcoming holiday season. So as Crystal said, we typically do these types of workshops on a regular basis to educate our clients and other people about estate planning issues. But for this particular workshop, we decided to build kind of a new one. This is the first time we've done this presentation, and it's about the dangers of do-it-yourself wills and estate planning. Right? So why did we prepare this presentation this time? Well, we do think it's because of COVID-19. There's actually some statistics out there that since March, online companies like LegalZoom have seen anywhere between 50 and 143% uptick in their online will services, right? And why is that? I think it's pretty obvious. People are fearful. There's a lot of bad news. There's a lot of uncertainty. People are deciding, hey, now I kind of need to get my affairs in order because of all the uncertainty out there. And so, we deal with do-it-yourself wills on a kind of regular basis, but we've actually, in our firm, seen a spike in do-it-yourself wills in the last couple of months. And fortunately, none of our clients have passed away from COVID-19 that had a do-it-yourself will, but we have seen some other recent ones. And I can tell you, without exception, every single one of those do-it-yourself wills has had at least one major problem that our firm has had to deal with. And we are able to deal with it, but let me guarantee you, when an attorney says that they have a problem they're going to have to deal with, that means it's going to cost more money, right? So that's really what this is all about. It's all about preserving money, preserving time, and making sure your wishes are actually carried out. And so why do people do it yourself wills? And I think it's, I think this is not brain surgery here, versus money. People think avoiding a lawyer is going to save them money in the short term. And it's true, lawyers do charge, they're not necessarily cheap. But as we will talk about throughout this presentation, a do-it-yourself will that's not properly done can actually cost a lot more money in the long term. Time, right? Lawyers, you meet with a lawyer, you meet with our firm, it's going to be a process. There's going to be some meetings, there's going to be a lot of questions. We're going to ask about your needs, your goals, your family, your finances, and we'll probably have a couple of meetings. It's actually a time commitment, right? And again, people say, hey, if I just go online, I fill in the blanks, I can do it a lot faster. Again, that's true, but in terms of money and time, we're really talking about an investment in making sure that your wishes are carried out and that your beneficiaries are taken care of. Other reasons why people do it yourself will, right? There's some immediate health crisis, right? Someone's going into surgery, they're diagnosed with an ill, and so they kind of get really scared, so they want to throw a will together really fast. Maybe they're traveling, that kind of just in case. I'm going to Europe with my wife, I'm leaving the kids with grandma and grandpa, and I want to have something just in case something happens, right? So there's lots of reasons that people do a do-it-yourself will, and they're all valid reasons on their face. It's understandable why you'd say, hey, let's just do it kind of the cheaper, easier way on the internet. But we're really here to talk about what are the pitfalls of that. Almost every time we meet with somebody or have a workshop, somebody always asks, well, can I just use an internet will? Right? And our answer has always been, well, they work until they don't, which is kind of a flip answer, but it's also accurate. Sometimes internet wills or handwritten wills, they work and they're fine and there's no problem. But like I said, more often than not, what we see is there's always at least one problem that could have been avoided. And so here we're really going to talk about what are those problems? What are the pitfalls? And so to begin with, as a very basic level, we got to understand what is a will, right? Black's Law Dictionary, which is what lawyers always look to, define a will as the legal expression of an individual's wishes about the disposition of his or her property after death, a document by which a person directs his or her estate to be distributed upon death. I think we all know what a will is. It's a writing that says who gets what, right? But more importantly, what is required for a will to be valid, right? Not much is actually the answer. For a will to be valid, first, the testator, that is the person writing the will, they have to have capacity. Now, capacity means different things in different contexts. You can have capacity to write a will, that's what we call testamentary capacity, without having the capacity to enter into more complex contracts. Really, to have capacity, all you need is basically you have to know that you're giving away property upon your death. You generally have to know what you have, and you have to know what the law says are the fruits of your bounty. Now, who's your family, right? It's a very low bar. You have to be at least 18. There's some special provisions if you've been previously married or in the military. You can make a will if you're under 18, but for most of our clients, they're over 18. And it has to be a written document. And there's two types of wills. There is what we call a holographic will, which is a handwritten will. And for that to be valid, the will has to be written completely in the testator's handwriting. Again, the testator is the person actually making the will. And it has to be signed by the testator. And then there's an attested will. This is the typical will you get off of the internet, or if you came to an attorney's office and they prepared for you, that's what it would be. It's basically a typewritten will. And that's fine as long as the testator signs it and it's witnessed by at least 2 other people who are age 14 or over. All right. And so what makes a valid will? Again, not much. This is a kind of quick and dirty will that I wrote. This is the last will and testament. It says, I, Joe Smith, being of sound mind, hereby leave this, my last will and testament. I wish for my children to share equally in my personal possessions. I wish all my financial assets to be shared equally between my wife, all my children, and then grandchildren. My nephew, godson, has autism, and I want to make sure that he has a home, so I leave him my house, signed Joe Smith. This is actually a valid will. In fact, we can go a step further here. We can actually take a napkin, and I can write, I, David Miller, leave everything I own to my wife Shannon when I die. Signed, dated, right? This is actually a valid will for me right now. If this building collapsed and I passed, this would be the will that controls. For that reason, I'm going to tear it up and revoke it because I don't actually want this to be my will. But that's all that it takes. Okay? And then the next question we have is, what do you do with the will? And the answer is probate. Now, a lot of clients come to us and they say, well, I have a will, so I don't need to go through probate. That's actually incorrect, but it's kind of a common misconception. If you die without a will, that is, you die intestate, then you will go through probate, and the court will determine through a kind of much more difficult process who gets what based on the laws of Texas, right? But if you pass with a will, you still have to probate that will. And what does that involve? Like I said, it's a court process. You got to go to the court and basically have them bless the will and give the executor the power to administer the estate. So what's involved in that? Well, you got to get the will into evidence. You have to have the will admitted into probate by the court. You have to have an executor or administrator appointed. Who's then going to receive the letters testamentary, which are court documents that give the executor powers over the estate. Then you file inventory and notice to creditors, and then you make distribution. Is this hard to do? Actually, the answer is no. If you have a valid, a good, solid will with the right magic language, in Texas at least, this is very easy. Texas is actually a great place to do probate if you're a beneficiary. Other states like California, New York, the lawyers make a lot more money doing probate because it's a much more difficult process. But in Texas, if you have a good will, then this really is more of an administrative process, and it's not that difficult. So the question then becomes, what can go wrong? You know, if it's so easy to have a valid will, and the probate process is pretty easy in Texas, you know, what's the problem? What's going to happen with an internet will or a do-it-yourself holographic will? And the first thing we want to look at is court formalities. This is the kind of so-called the magic language that we talk about that we build into our wills. And to begin with, it's important to understand that a will in Texas, a will that was made in Texas, is valid in any state of the Union. It's valid in Texas, Nebraska, California, New York, wherever. States have to recognize the wills from another state. But, and here's the big but, is each state might have different rules and different formalities that a will has to follow. And so while the will might be valid, getting it through the probate process can be more difficult and more expensive and more time consuming. And so what do you have to do, at least here in Texas? Again, you have to get the court to accept the will into evidence and the public record. They actually have to say, okay, we are going to recognize that this is a valid document. They have to recognize that this is the right will. Okay, you saw me with my napkin will actually tear it up. In Texas, that means I actually revoked that will. If you have two competing wills, you have to determine, the court's going to ask, you know, which will is the one we're supposed to look at. Does the new will revoke the old will? Is it later in time? These are the questions, which one is the right will? They're going to have to select an executor. All right, who is going to be in charge of the estate? They might require that executor to post a bond, and then they have to decide about independent or dependent administration. And this, again, is important. Independent administration means once an executor gets their letters testamentary, they can do whatever they want so long as they're going by the terms of the will. They can make distributions, they can reimburse fees. If you have dependent administration, that means every time the executor wants to do something, they're going to have to run to the court and get the court approval. They want to reimburse themselves for legal fees, they have to ask the court for permission. They want to make a beneficiary distribution, they have to ask the court for permission. Pay a creditor, again, ask the court. So what you see here is it's a much more difficult process. And again, when you hear difficult process, that means more time and more money. And so what can go wrong if you have a do-it-yourself will that doesn't have the right magic language, that doesn't follow the correct formalities? It might be a valid will, like that napkin will or the will I showed you before, but there might still be real issues. First, the court might require an executor to post a bond to serve as executor. That's going to be time-consuming and expensive for the executor. They might say, I don't want to do that. I'm not going to serve as executor, find somebody else. So now you have maybe the wrong person overseeing your estate. They might require dependent administration. Again, we talked about that. That's more time and more money. If they can't even determine who the executor is, they might appoint a court-appointed ad litem to oversee the estate. That is, if there's no executor, the court's going to select an attorney to carry out the wishes of the will. And do you think that attorney is going to work for free? No, they're not. And they're going to charge the estate. And so it's going to cost the estate a lot more money to work through a court-appointed attorney rather than an executor you selected. They might find something in the will that is legally invalid. You might have had intended to do something in your do-it-yourself will, but because of the way you said it, or because of exactly how you're trying to accomplish that, you actually are in conflict with the law. And so the court is just going to strike out that clause. The court might find or determine that you inadvertently excluded somebody, and they might add unintended beneficiaries. For instance, maybe someone wanted to disinherit their son, but they didn't specifically follow the formalities, and now the court's going to write the son back into the will. Or worst of all, the court just rejects the will outright. Says it's not a valid will because it didn't meet one of the qualifications. And what's the effect of that? Well, if there's an older will, they're going to look to that older will, which might now be incorrect. Or they might just say that you've died intestate and follow the Texas rules of succession. All of these issues are going to cost time. They're going to cost a lot of money. And worst of all, you might end up having your stuff, your assets, end up in the hands of people that you didn't want them to get, or in the wrong proportion. So that's kind of the formalities of what's going wrong and the pitfalls of some of the do-it-yourself wills if you don't know the magic language. But the next problem that you could have is kind of the substance of the will. Did you really say what you meant to do? All right, and this is where kind of the wordsmithing from an attorney can be very helpful in accomplishing your goals versus, kind of doing it yourself. And so what are those substantive issues? Well, is the will clear about your intent? Is the language you're used clear to a court or a judge? Does it provide for a decision maker? Does it state a clear line of succession? Is it giving money to someone that you don't want to inadvertently? Does it provide for those who need special care? Think minors, people who have some sort of disability that might need special dispensation. Does it have provide for heirs with what we call other issues? Think someone who's a spendthrift, someone maybe has a substance abuse problem, somebody who's a serial entrepreneur that's always getting sued. Heirs that you might want to provide for, but also want to put special protections and special instructions on their gift. And finally, does the will comply with the law? Right? And so let's go back to the kind of do-it-yourself will, and kind of we'll look at some of the problems here, right? So again, we've read this before, but one of the big problems, right? Well, first of all, there's no date on this document. That doesn't make the will invalid, but it does raise the question, if there is another will out there, is this the new will? Is it revoking the old will? Is this the correct will? There you might have a contest. What document are we actually supposed to be looking at? All right. There's no executor named in this will, which again doesn't make the will invalid, but it does result in the court is likely going to appoint a court-appointed administrator who is going to be under dependent administration, and all that is going to charge to the estate. And so, whereas probating a well-done will might have cost $3,000, $3,500. Now you're looking at legal fees of $10,000, $15,000, $20,000, or even more, depending on the issues that arise. What else is wrong with this? It says, I wish for my children to share equally in my personal possessions. Well, that makes sense. I have a bunch of stuff and I want my kids to share, right? But, who decides who gets what? I mean, this presumes that the children are going to share and agree. But if they all want dad's hunting gear, if they want dad's artwork or his army uniform for sentimental value, and they can't agree, you're going to have a fight. And there's no executor appointed, and there's no dispute mechanism in here. And so what you're going to have is family discord and fighting over stuff. Much better to be specific about what you're giving. Here, there's no definition of personal possessions and financial assets. Now, this is where lawyers, especially in litigation, get really nitpicky about words and the meaning of words. So, what is that exactly is being given away and to whom? If I have a collection of gold coins, is that personal possession or is that a financial asset? Could be both. What about real property? What about a summer home? Is that a personal possession or a financial asset? Don't know, right? You're going to have a fight over what that means. There's not really a clear intent here. It says, I want my assets to be shared equally between my wife, all my children, and then my grandchildren. But what exactly does that mean? That probably means, first, I want my wife to get everything. If she predeceases me, then my children. And then if they predecease me, then my grandchildren. But does it really say that? It's a little ambiguous. Does it mean it goes to my wife and my children and they have to share it? Or my wife, my children, and my grandchildren, they all have to share it? Again, it's not clear. It could be ambiguous. And if people aren't agreeing and people disagree on how to interpret it, that's going to be a fight. And that's bad for everybody. Doesn't really say who the children are. Does that mean my natural children with this wife, stepchildren, children from a prior marriage, adopted children, someone who's not related to me in any way, shape, or form, but I always treated as a child? That could be a problem. It doesn't give any sort of instructions for what happens if one of these children or grandchildren are a minor or are spendthrifts or have a substance abuse problem. It doesn't provide for any protections for that person, or maybe from a bad spouse that they marry. Are minors inheriting? There's all sorts of issues about the way they are going to pass money to various people. And finally, we talk about things complying with the law. There's a special gift in this will for a nephew who has autism, and it's the house, right? And it kind of makes sense. I'm leaving my wife a bunch of financial assets; she'll be fine. But I want my nephew to have a place to live and give him a house. Well, there's two things wrong with this. One, this is not legally valid. You can give that gift to the nephew, but under Texas law, the wife still gets to live in the home for at least a certain amount of time. Second, if that nephew is getting some sort of public benefit, this gift might actually disqualify him from those public benefits down the road, which could leave a lot of money on the table, right? And I know it could be a little silly. This is, like I said, a really bad will with a lot of problems, but I promise you, every single one of these problems are real issues that somebody has dealt with on a will at some point in time. The case law in Texas and throughout the country is just chock full of litigation about interpretations of these very issues that I kind of raised. And so while this example might seem a little silly, it's real. I mean, these are real problems, and it's not just the handwritten wills. If you're using LegalZoom and you're filling in the blanks, if you don't fill in the blanks correctly or don't understand the effect of the blank that you're filling in, it can create these ambiguities and these problems. And so it's a real issue. So what are some other problems? Well, there's unintended litigation. And this is, again, something that we've seen come up a couple of times in our practice, which is, the question of, hey, we did this internet will, who filled in the blanks, right? Was mom actually sitting at the computer typing in the blanks, or was her son or her nephew doing it for her? Did they mess up, right? Did they fill in the blanks properly? Did they understand what they were writing? Did they interpret her instructions properly? Was there undue influence? Were they filling in the blanks the way that they thought it should be drafted, and then convincing mom to sign the will? Are the proper witnesses? Did the person who was helping make the will engage in the unauthorized practice of law? And all of these types of issues, if people don't agree on the will, and there's a fight over the inheritance, these are the types of issues that are going to be raised in litigation. And again, litigation, it costs money, it's heartbreaking for the family, takes a lot of time, and it's really going to hurt the gift that you're trying to leave to your family. Other problems that can come up with do-it-yourself wills. Well, you need to make sure that your will works with beneficiary designations and ownership of other property. You can't just look at the will by itself. There's other ways of passing property, and you want to make sure that the beneficiary designation on your IRA makes sense given what you're leaving in your will. There could be claims against the estate, right? We do a lot of public benefits planning here for seniors who use the Medicaid skilled nursing benefit. And if they don't have their estate done properly and their assets in the right place, then when they die, the state can actually sue the estate for the benefit that they receive. It's called the Medicaid Estate Recovery Program, or MERP, right? Is there a way to avoid that? And again, the will only affects what happens to your stuff once you've passed. It has no effect on what happens to you or your stuff while you're still alive. And arguably, for a lot of people, they're a lot more concerned about what's happening to them and their stuff during the time they're alive. They're more concerned about that than what happens to their stuff once they pass. And the will doesn't do anything related to that time period. And so, do you have all the documents you need if you do a do-it-yourself will? Probably not. And even if you do have some of these documents like powers of attorney, are they filled out correctly? Do they comply with the statutes? They can be really easy to mess up. And so again, it's not, a do-it-yourself will. There's a lot of pitfalls here. So the question is there a better way? And the answer is yes. And of course, this presentation by an attorney, we're going to say see an attorney, but there's a reason we say that, right? There's actually things that attorneys can provide. First, when we write that will, we will make sure the will is clear, that it's proper, that it meets all the requirements, that it has comports with the law and comports with all the formalities that the court's going to require. That's going to make probate faster, easier, and cheaper. And attorneys might also find simple alternatives so you can avoid probate altogether. I have a client right now who has a will. His wife passed away recently. She has a will. It's a valid will. It's got no problems with it at all, and we will go through the probate process, and it will be easy. But the only thing that they are trying to probate is title to the house. With that being the only asset at issue, we could have avoided the probate process for a couple $100, right? Rather than going through the time and expense of a full probate. So there's alternatives that lawyers can speak with you about. So what else can attorneys provide, right? I think the important thing here is a will is often not enough, right? The will, again, even a do-it-yourself will that is perfect in every way and has no problems, it's not going to help you avoid probate. It's not going to protect your assets. It probably is not going to protect your heirs' inheritance. It could really not avoid litigation and disputes to the extent that if you worked with an attorney, you could really identify who the fly in the ointment is, where a lawsuit's going to come from, how do we avoid that. Guardianship. Guardianship is a really big deal right now. What guardianship is if a court finds that you're incapacitated and you need to have your rights taken away from you and have a guardian, think a legal parent, oversee all of your decisions, that's the guardianship process. And sometimes that's not avoidable, but in many, many, many cases, it is avoidable. And you want to work with an attorney to make sure that you avoid guardianship at all costs, because it's a terrible process. It's bad for a lot of different reasons. It's bad for the ward, it's expensive, it's difficult, it's time consuming. There's a lot of unintended consequences of guardianship. And a do-it-yourself will is not going to help with those types of issues. And finally, we're going to make sure you have all the documents you need. So here is, kind of circle back to the beginning. Why do people do a do-it-yourself will? It's generally money and time. But here's where we say an ounce of prevention is worth a pound of cure. When you meet with an attorney and have a proper will and a proper estate plan put together, what you're really doing is you're investing in the future to make sure you're protected during your lifetime, to make sure your assets are protected after you pass, to make sure your beneficiaries don't have to go through a long, difficult process, and to make sure your wishes are carried out. That is all that we have. If you have further questions, we certainly invite you to contact our firm and set up an appointment. Otherwise, if there's any questions, I think Crystal has the chat line open. Crystal, are there any questions available?
Not at this time, but feel free to email or call us. Again, there will be a survey that goes out that you're also allowed to input your contact information into if you'd like a consultation or if there's anything else we can assist you with.
Okay. Well, great. I thank you very much for your time, and I hope you get to enjoy the holidays. Thank you. Bye-bye.